Hi, thanks so much for tuning in. You're watching BQ Prime. My name is Alex Matthew, and this is Infravisioning, the show that gets you the latest from the infrastructure sector here in India. Joining me, as always, is Vinayak Chatterjee, who is infrastructure expert and founder and managing trustee at the Infravision Foundation. Thank you so much, as always, Vinayak, for taking the time. Now, we're speaking about the power sector today, and specifically about power generation companies. And as you mentioned in an article that you have published recently, this is not something that is new. The woes of the power sector, so to speak, all seem to land at the feet of the discoms. And this most recently has been observed by the Supreme Court of India in a judgment in the matter of GMR Energy Varora Limited versus Central Regulatory Commission and others. Before we start on that judgment, though, as a student of the space, can you explain to my viewers why all of these problems seem to stem from the power distribution companies?
That's the question that is often asked, and it is popularly said in the power sector that it is the discom tail that wags the power sector dog. And the discoms have actually been the source of much friction on two sides, vis-a-vis consumers when they raise tariffs and vis-a-vis their payments in time to the suppliers of energy from the generators of energy. So while the buyers of electricity have very little voice, because it is the regulatory authorities that set tariff, and that's almost a semi-judicial process. What has happened to the generators is that they feel very suffocated, stifled, and frustrated with what one would broadly call as a dysfunctional commercial behavior between the discoms and them. If you speak to any power generator, whether it is traditional coal-based or renewable, they will tell you their woes vis-a-vis their interaction with discoms, how difficult it is to get a genuine cost passed through in the tariff, or how difficult it is to get payments in time, and also the payments which have been directed by various authorities like the state regulators, because they always go around. The discoms traditionally go around challenging every dispensation handed to them by the judicial or semi-judicial system. So we finally have, as you rightly observed, in the April 20th judgment that the Supreme Court gave in the case of GMR Varora Energy versus the CERC, Central Electricity Regulatory Commission, and others, there are some very, very strong points that the lordships have made. They broadly fall into five categories, but there are 2-3 fundamental ones. And the first one is that when there is a change in law, all contracts between a supplier of power and a buyer of power, between a generator and a discom, has very strong legal contracts that set out the roles and responsibilities and liabilities of different parties. And it very clearly sets out that when there is a change in law, for example, if the government imposes a green cess on coal, or if there is a change in the taxation structure, the GST comes in and replaces something else. If there are genuine facts that change the costing structure of the generator of power, which is a change in law, then the regulators who determine tariff are authorized to allow the costs, whether the increase or the decrease, to pass through the system and end up as tariff to the consumers, so that the generators recover the genuine cost increases that have happened to it. Now, cost decreases normally don't happen. It is really cost increases that happen. For example, the government recently put a duty on the importation of solar modules from China and related countries. Now, when you put a 30% duty, obviously the cost of solar panels go up. And if the cost of solar panels go up, the power supplied by a solar installation go up. So these are issues which are change in law, which the generator has no control over. And therefore, it is logical that insofar as they affect the cost of producing power, that gets passed through. So the point I'm trying to make in this rather complicated scenario is that whenever such an obvious change of law happens, the discoms, instead of allowing an increased tariff, go around challenging it. So the state regulator says, yes, you can increase the tariff by X paisa, whatever, by 50 paisa or so. Then the discom, instead of just agreeing and getting on with it, goes into a whirlpool of challenging that tariff increase.
And that seems to, in fact, be the crux of quite a few of the observations that you've made of that judgment, where the Supreme Court is saying that you are making unwarranted, unnecessary litigation, and that's just complicating the process. It's clogging up the court's time, and it's also resulting in what you have pointed out, late fees in several situations, right? So I think your next observation had to do with the fact that the Supreme Court is saying that appeals to the Supreme Court should only be permissible on substantial questions of law and should not be permissible otherwise. Would this significantly reduce the number of litigations that distribution companies can take up?
Well, the jury, which is the most appropriate thing to say in today's program, is still. I mean, the Supreme Court has directed and has advised. Now, is this going to change discom behavior? The expectation in the market is that it will, because people will now start quoting this judgment and saying, why are you going into litigation? I mean, why don't you just follow what the regulator has said in terms of increased tariff? So the second point is related to jurisdiction, and it's a related point. The Supreme Court has also said that these are technical subjects. The exact amount of compensation that is due in a tariff increase based on an increase in price of domestic coal or a change in law or a change in taxation, these are very, very technical issues. And therefore, there are competent authorities like the Electricity Regulatory Commissions and similar other bodies. And there is an appellate authority called APTEL also. These are technically qualified bodies to pronounce their verdict on such potential increases in cost and related tariffs. So the Supreme Court said that if you've got recent technical judgments from these approved bodies, then why are you bringing these cases to the Supreme Court? So this is the second point they've made. The first one was, of course, change in law. And the second is about jurisdiction, that the other bodies are fully within their rights to give dispensations on tariff increases and take a view on costs, etc. Why should you be bringing this up to the Supreme Court? So they brought up the issue of jurisdiction also, but over to you, Alex.
No, absolutely. And the third point that you're making has to do with what I was talking about earlier, which is the late payment surcharge, which comes into effect when payments are delayed by distribution companies to the generators. And usually this has taken place based on what I've read in your article as well, and based on what we've seen over the course of several years in the power sector, litigation that is initiated by these distribution companies. So what it's essentially saying now, Vinayak, is that the court is asking these distribution companies to pay first and then litigate if they have to, right?
So there are two aspects to it. I'll come to the pay first a little later. The more important point is there are two impacts on the cost to a customer. By merely litigating, the discom is accumulating charges for which it is not paying the generator in time. And once they're proved wrong, they're asked to pay up. Then they have to pay not only the charges, the payments that they've held up, but also a surcharge called the late payment surcharge, LPS. Secondly, in the process, they're also accumulating huge legal fees. Now, what they've been doing traditionally is using both the late payment surcharge, which is an additional cost, as well as huge legal fees, adding all of that and saying that this is the cost of doing business, so pass on that to the customer as a tariff increase. So the Supreme Court says, hello, I mean, your behavior in constantly litigating and delaying payments is in the ultimate resulting in increased tariffs to the customer. So you can't do that anymore. It's a very simple point, right? So that's the point that the Supreme Court is making, saying you can't do it anymore, right? It further says that if a competent authority, now that's coming to your second point, if a competent authority has said that, yes, Mr. Discom, you have to pay this amount to a generator, then the Supreme Court says you first pay. After that, you litigate. And if the litigation is in your favor, you can always demand a refund. So that's the further step that the Supreme Court has added to the strictures that they've made already.
Yeah, and it's also pointed out that any late payment surcharges that arise out of the delayed payments because of litigation cannot be passed on, which is, I think, would be quite significant. I want to focus on your fifth point, which is you're talking about the fact that the judgment observes, or rather the Supreme Court observes, that the power that has been purchased from independent power generators is actually lower than the power that is purchased from state producers. Why is that?
I have myself been a little surprised with this. So what effectively my view is that the state gencos have fairly long-term PPAs.
Okay.
25 years, 30 years at prices of yesterday, which were far higher. Since then, in a competitive market, prices tend to fall also because of the competition from renewables. So there is this anomaly that the discoms, in their commercial interaction with private sector producers, tend to be far more harsher in terms of getting the best contracts and litigating far more with the private sector producers than they do with the state generating companies. So this observation by the lordships came as a surprise to many people who read the article, who later called in by saying, this is interesting, that we are even saying that there are certain, underlying differences in behavior commercially between the discoms interaction with the private sector and with central or state sectors.
Is it also, and you pointed out this already, but is it also because a large number of these private players are in the renewable space, and renewable energy per se is cheaper in the market?
That is true, and it wasn't always. In fact, a few years ago, programs like yours, we used to discuss how soon will renewable energy attain grid parity, which means how long will it take for them to match the prices of coal-fired generators. Now we are talking about a reverse situation. We are talking about situations where renewable energy is actually working out cheaper than coal-fired. So it's leading to a lot of pressures and counter pressures in the commercial world of buying and selling power between a discom and a generator. But the revelation by the lordships is illuminating to the extent that commercially the discoms tend to be far harsher with the private sector players than with statal counterparts.
Okay, so let's talk about implications then, because I believe that the judgment or the Supreme Court is calling for the power sector to step in and to put a process in place to reduce the number of litigations that could take place, and that seemingly could improve the health of the sector as a whole. Are you positive? Are you optimistic on that effect taking place in the near term, or do you still see pitfalls down the road?
Look, I am going to read out a quote from the judgment for your viewers. So the key point ultimately boils down to the court saying to the Ministry of Power, open inverted commas, the Ministry of Power may evolve a mechanism to avoid unnecessary and unwarranted litigation, the cost of which is also passed on to the ultimate consumer. Close inverted commas. So basically, the Supreme Court is now telling the Power Ministry that you issue the necessary guidelines, directives, strictures, whatever it is, to prevent the hinterland of discoms burdening the courts further with this kind of useless litigation that it has been used to in the past. So my view is now that, emboldened by the Supreme Court judgment, the Power Ministry should, since judgment is pretty fresh, 20th April, my view is that the hands of the Ministry of Power has been strengthened with this Supreme Court judgment, and I am expecting some very strong guidelines issued by the Ministry of Power to the discoms to prevent needless litigation, and from the Central Electricity Regulatory Commission to also use this judgment to say that don't bring frivolous litigation. And I think this judgment should also be used by the civil courts, including the Supreme Court, to actually not allow cases to reach them for judgment. They should just say it's not our jurisdiction. if the people have given you a final verdict, live with it. So all these things are expected in the months ahead. But as I said, wait and watch the space.
So to close out this conversation, speaking about the health of discoms as well, you pointed out that they remain and they continue to be a bit of a weak link in the chain of the power sector. In the context of the political environment and the fact that a lot is being promised, specifically with regard to free power in several states, do you anticipate that that will complicate matters?
It should not, because what the guidelines are very clear is that if I promise free power, the discom gives it free and raises a bill on the state exchequer to compensate them for the free power. Now, historically, what happened is you gave the free power and then you forgot to compensate the discom for it, because the discom is not giving it free. It's a commercial entity. Yes. It is the political establishment that is giving it as an elected government to its people. So the government, the state government, has to compensate the discom for the subsidy that is built into the tariffs. So historically, the state government was very shoddy in paying up to the discoms in time. Even that area is getting cleaned up now with very strong focus that subsidies have to be paid in time. So if the movement is in that direction, it should be less and less a worry for the future.
So let's hope that things improve in the sector. Certainly something to talk about over the course of many weeks. Thank you so much, Vinayak, for taking the time. Pleasure speaking with you as always. Do stay tuned. Lots more coming up on BQ Prime.